Good morning, everyone. Welcome to the pre-retirement seminar for instructional staff. The presentations today all pertain to pensions and retirement. Today we are going to hear from a representative at TIAA, Tamara Telesco, who is going to talk about estate planning. I feel that that is a very valuable presentation for all of you. While it doesn't actually replace hiring an estate planner, it gives you enough information to be a starting point, so that when you do hire someone, you know the questions to ask and the options that you have. So you're a more educated consumer when you seek out those services. The next presenter is going to be Peter Quinn from the 457 plan. And the reason why I invite the 457 plan representative is because the 457 plan is a unique investment option for you in that even if you are contributing towards a TRS or a TIAA TDA, and you are maxing out on whatever that IRS limit is, you can double that limit by investing in the 457 plan and maxing out on that, because the two balances are not coordinated. So they don't come into conflict with one another. You can max out on both plans simultaneously and still remain within the IRS guidelines, the IRS limits. So even if you are still a year or 2 or 3 away from retiring, it's an opportunity for you to put away some more pre-tax earnings as you lead up to your retirement. So I think that the 457 plan is a very valuable plan to you, and I hope that you consider utilizing it. But Peter will go into a lot more detail about how the plan works. The rules are slightly different, the withdrawal rules are slightly different, but it gives you an opportunity to double what you can put in a tax-deferred annuity. And then at around 10:30, we are going to have simultaneous presentations from the TIAA representative, and anybody who is a participant in the TIAA plan will remain in this room. And then for the TRS members, we're going to provide a separate Zoom link in the chat function, and you will log in to that Zoom link to be able to go into a separate Zoom meeting with the TRS representative. At the conclusion of that presentation, that will be the end of this entire morning program. You do not have to come back to this meeting. You can just log off and you'll be done for the day. So with that, I would like to invite Tamara. You can share your screen and begin your presentation.
Thank you. It's a real pleasure to be here. Let me just set this up and we can get started. As Talon mentioned, my name is Tamara Telesco. I'm a director of wealth planning strategies at TIAA. My background is I am a tax and estate attorney by background. And today I'm going to be discussing common estate planning considerations. As Talon mentioned, this is your webinar. If you have any questions, I am more than happy to address them. If I can answer them, I will be more than happy to do so. So I think I'll get started if that's okay with everyone. I think when people hear the term estate planning, they automatically think of wills and trusts, and maybe even probate. But there's also many estate planning documents you should have while you're alive that will make your life a lot easier. So today's presentation is going to discuss both. In planning for your lifetime, we'll discuss the documents you can put in place to protect yourself and your finances in the event you're disabled. We'll also discuss lifetime giving to both charitable and non-charitable beneficiaries. And then when discussing estate planning documents at death, we'll review wills and revocable trusts and how titling of your assets and beneficiary designations work with your plan. Finally, we'll briefly look at estate taxes and whether tax planning should be part of your estate plan. So with that, let's get started. As all of us know, there may come a time in each of our lives when we are unable or unwilling to handle our personal or financial affairs due to a disability, whether it's mental or physical. Discussing this with loved ones, such as what care you would like to receive in the event of a disability, who would provide the care, and the cost of such care can be a difficult decision. So, if you were to become incapacitated, what would happen to you? There are a number of things to think about pertaining to both your medical care, medical wishes, and financial affairs. You'll also want to consider who will make decisions on your behalf if you become incapacitated. You can name one or more individuals to act on your behalf to make financial or healthcare decisions in the event you are unable to do so yourself. There are certain legal documents that you can sign that designate someone to make these decisions for you. When considering who you want to designate to handle your financial affairs, think through their financial acumen. Would the person you designate know how to manage assets and make decisions? Or would they know who to rely on for such assistance? Their lifestyle. Do they have the time to ensure that assets are managed in the manner that you wish? And equally important, their geographical location. Will they be able to physically tend to any matters that need to be tended to? There are a couple of documents that your attorney will likely prepare for you as part of your estate plan that can provide some guidelines in the event of your incapacity. The first is a power of attorney for financial purposes. A durable power of attorney will authorize a named individual to act for you in most financial transactions as your attorney in fact. Each state has their own power of attorney. So if you move, you should get one from that state. You can customize the power given to them to allow for maximum flexibility or limit the flexibility to certain events. And the example I give for limiting it, if any of you have ever sold or were in the process of purchasing real estate and used a real estate agent, you actually gave the real estate agent a limited power of attorney over that transaction so that that real estate agent could act on your behalf when negotiating a fee or looking at properties and seeing what's available. All of that was a limited power of attorney. There are several provisions that you could consider adding to this document. For example, the power to make gifts. Let's just say that while you were able to, you consistently made gifts to certain individuals during your lifetime. If you become incapacitated, you can give your attorney, in fact, the ability to continue to make those gifts even though you are incapacitated. Another power you could add is the power to change beneficiary designations. And the questions I always get is, why would I ever want anyone to change my beneficiary designations? And the answer is circumstances change. Perhaps when you made that beneficiary, named that person as your beneficiary on your retirement plans, it made sense. That's who you wanted to name. but wonder if that person themselves becomes disabled and they're collecting government benefits. When you pass away, if they inherit your retirement accounts, that could actually interfere with them collecting government benefits. So you may want your attorney, in fact, to either have them inherit in a special needs trust so that it does not interfere with government benefits, or perhaps give the assets to their children if they have children, and that makes sense. So that might be, it's just circumstances change. And another power you may want to add is the power to transfer assets to trusts. And we're going to talk about that later in the presentation. So, a durable power of attorney will legally enable your attorney, in fact, to act, as I mentioned. However, you should be aware that some institutions have their own forms, which they want you to complete. So if you have a bank account at Citibank, or you have a bank account at Bank of America, or a brokerage account at another broker, they may have their own power of attorney. And again, that's a limited power of attorney because it will only be effective on the assets that you have with that institution. But you should contact your institution just to see. They should recognize your power of attorney that you have drafted by an attorney. And in fact, New York, back in 2021, they changed their power of attorney a little bit. They added some modifications, but one addition that they made was that an institution has to accept a New York statutory power of attorney within 10 days of you submitting it. And if they don't, they're subject to penalties and interest and everything. So I just want you to be aware that's been a problem or an issue in the past, that some institutions are real sticklers and they want you to name them, use their power of attorney. But in New York, statutorily, you do not have to, and they have to respond to you, the institution, within 10 days. So what happens if you don't have a durable power of attorney? Your family members may have to petition the court to be appointed conservator of your assets. And the poster child for this is Britney Spears. You may recall, after a series of public incidents, and there were concerns about her mental health, a California court placed Britney Spears under a conservatorship. And believe it or not, that conservatorship lasted for 13 years. It started in 2008 and finally ended in 2021. So this conservatorship gave her father, Jamie Spears, control over her finances, her career decisions, and her personal matters. So as you can see, if you don't have a power of attorney, getting a conservatorship can be both time-consuming and costly. So I work with a lot of attorneys, and a lot of attorneys recommend that if your durable power of attorney or power of attorney is over 10 years old, you should get it updated. I have never personally known anyone to have their power of attorney rejected because it was too old. However, that being said, I think it's a good idea for no other reason than to make sure that maybe the people you named or the person you named 10 years ago is still the person that you want in that position. In addition, I think it goes without saying, make sure that the person you name in this capacity is aware that you named them as your attorney, in fact, and that person or people have a copy of the durable power of attorney. Okay, now let's move to revocable trusts. A revocable trust is a trust you establish during your lifetime. It's revocable. You can revoke it. It's an alternative to a will. And while revocable trusts can provide for the transfer of assets at death, which we'll discuss later, they can also provide for management of your assets during your lifetime. The grantor is the term for the person who creates the trust. So, for example, if I created a revocable trust, the title and the beneficiary of the trust, the title would be the Tamara Telesco trustee of the Tamara Telesco Revocable Trust. Revocable trust can provide for successor trustees to step in. If, for example, I become incapacitated, there would be a successor trustee to me, and that person could assume management of the trust assets. If you transfer assets to the revocable trust during your lifetime, the trust terms control how those assets are to be managed in the event of your disability. However, you still need to have that durable power of attorney that we just talked about, because you cannot transfer retirement assets to your revocable trust during your lifetime. If you transfer revocable trusts to your retirement assets to your revocable trust, it would be considered a distribution, and you would have to pay all the income taxes due on that. And then the proceeds could be put into the trust. So you really should not transfer retirement assets while you're alive to a revocable trust. Okay.
Tamara, there are a
Yeah.
couple of questions. Can we get to them? So with a durable power of attorney, can a trust beneficiary be changed? Or
Well, a
maybe they're not
durable
really,
power of
really related.
attorney, yeah, a durable power of attorney is not a trust. It's a document that names someone as your attorney in fact, and you can change it. It's not irrevocable. So you can with a financial durable power of attorney, you can name one person, you can name a successor to that person, or you can name multiple people, and they have to act together, or they can act separately. That's your choice also.
And the other question is, what is there to be worried about a bank or other institution not accepting a power of attorney, not honoring a power of attorney?
Well, if the asset is in your name,
Sorry, that wasn't exactly
and
the question.
right, if the asset is in your name, let's just say you have an account at Citibank.
Okay, one second. Claudia,
okay.
do you want to ask your question? And
Yeah,
if I
sorry,
didn't,
that,
if
that
I
wasn't
didn't represent.
exactly the question I put. I was wondering, like, if you don't go out, make a specific other person a power of attorney, what do we have to worry about a bank or another institution that has our money doing with their own power of attorney?
If so, let me just make sure. If you don't do theirs, I mean, maybe they'll accept yours. Is that
So
what you mean?
if you don't do your own,
Oh,
what
I'm
kind of
sorry.
worries
Then
do you
the
have?
asset, yeah, the asset, if you become disabled, probably nobody can do anything with that asset. And when you pass away, it will be part of your probate estate.
Okay, thank you.
No problem. Anything else? Okay. So now let's talk about living wills and healthcare proxy. So the power of attorney is for financial matters. Living wills and healthcare proxies are for medical matters. So with a healthcare proxy, it's important to consider who will make medical or other healthcare decisions on your behalf in the event you are incapacitated and unable to make those decisions yourself, such as authorizing certain treatments, and admitting or discharging you to or from a hospital. The person you appoint to make healthcare decisions on your behalf does not necessarily have to be the same person you appoint to make financial decisions. For example, I'd say if you have a friend or a relative who has a medical background, that person may be your choice to carry out your healthcare wishes. It's important to appoint someone who you trust to carry out your wishes. And as with the other item, before deciding who should make medical decisions for you, think through their geographic location. Does he or she live close enough to you so that if they could be present in case of an event of a medical emergency? And also think about their emotional ability. Will they be emotionally able to carry out your wishes, or will that weigh on them heavily? A healthcare proxy may also incorporate a living will. A living will is your written instruction to healthcare professionals as to the withholding of or withdrawal of certain types of medical treatment, and as to desired treatments in the event you are unable to participate in the decision-making process at the time the treatment is rendered. And these are very, very common documents now. I mean, you go to any physician, someone is usually asking, do you have a living will, right? Whose name is your healthcare proxy? But this was a long time in coming. The way that we do this now is so simple, but this involved many, many court cases. One that probably many of you are familiar with back in the 70s is Karen Quinlan. Her family, led by her father, sought to have her removed from a respirator, but the hospitals and doctors refused. And it really was the start of getting these documents to be commonplace. This case went all the way to the New Jersey Supreme Court, where they ruled in favor of the parents and said the state's interest in preserving life did not outweigh the patient's right to refuse medical treatment. 20 years later, in the 90s, we're still fighting this, right, was the Terry Schiavo case. And this case came out of Florida. And this was a case between her husband, who wanted to take her off of life support, and her parents, who did not. It took 7 years in the court systems, going through the court systems, until she was finally removed from life support. So we take these documents for granted, but this was a long time in coming and many, many court decisions. Then in 2003, the Health Insurance Portability and Accountability Act, which we commonly now refer to HIPAA, became effective. And HIPAA allows whoever you name in your healthcare proxy to access your medical records. Your healthcare proxy should contain that provision authorizing the agent to serve as your HIPAA representative in the event of your incapacity. So far, we've been talking about making sure that you're all set if you become disabled. Now let's switch gears and talk about lifetime estate planning strategies you can employ, specifically how you can make gifts to others.
Excuse me, I have a quick. I'm in the process of doing a will right now. And the question is, the durable power of attorney and the healthcare proxy, are they separate documents, or are they documents that you attach to the will?
Yeah, it depends. In New York, there are two separate documents. One you sign, the living will you sign, and that says, who you're naming as your, representative. And the healthcare proxy in New York is more a check the box. Under what conditions? I can't feed myself, I can't breathe on my own, those kind of things. And you say whether you want resuscitation by any means, or you don't. So in New York, they're two separate documents, but some states have them intertwined as one.
So, but in New York State where I am, do we have to have two separate documents? That is the will, which is separate from the durable power of attorney and the healthcare proxy. Is that right? They're two separate documents.
Correct. They're two separate documents. Your healthcare proxy is a check the box, and your living will is a statement as to who you want to act on your behalf if you become incapacitated.
It's a separate document that I would tell the lawyer that the will does not cover this.
Correct. Okay.
Tamara, there are a couple, can we get to a couple of questions in the chat?
Of course,
Okay.
that's why I'm here.
Okay, just to clarify, a POA can, can handle retirement accounts, 401ks, 403bs, 457, etc.
In the respect that if you have, they can change retirement beneficiary designations in the document, then yes.
Okay,
But that's not the normal statutory information. Each state, New York State has a statutory power of attorney, and it does not have that power in it. So if you want someone to be able to handle your retirement assets, that's where you need an attorney to add those kind of provisions into your power of attorney.
okay. If you, do you need a healthcare proxy if you have a living will?
Yes, because they're two separate documents. So the living will just says who you want to act on your behalf. So it's a will naming someone to act on your behalf. The healthcare proxy is to check the box under what conditions you want that person to act.
Okay, and finally, if you don't have someone to designate as to designate power of attorney, can an attorney be identified as someone to handle your estate?
Yeah, any person can be. Yep,
Okay,
any person. There's not a lot of, I don't know of any institution that will do that, but any person will do that.
thank you.
Sure. So we're now talking about gifts. So there's non-tax advantages to making gifts, obviously, during your lifetime. It's, you know, the enjoyment of seeing the person enjoy the gift. It's to provide for sometimes you want to help with education, support, or financial well-being, or you can actually use it as an opportunity to see how well, you know, the person that you're giving money to handles the money, because it's, you know, basically a peek into the future as to how they may handle the potential inheritance that you have for them. There are also tax-oriented advantages to do it. It could reduce your estate tax liability. The current value of any assets given and the appreciation of those assets get excluded from your estate. And if the person you're giving the gift to is in a lower income tax bracket than you are in, it can actually be an advantage because they would be paying less income taxes on the interest or dividends if you gave them stock than you would be. So the federal transfer tax system combines tax-free amounts you can transfer during your lifetime or at your passing. You may give an unlimited amount to your U.S. citizen spouse and or to qualified charitable organization. So the example I give, if Warren Buffett gave his entire estate to Mrs. Warren Buffett, there would be no federal or state estate tax because you can pass any amount to a spouse. And the qualified charitable organizations that I'm referring to are organizations that are recognized under 501(c) of the Internal Revenue Code. Now, if you are married to a non-US citizen, you are limited. You do not have that unlimited marital deduction. You are limited as to the amount that you can transfer to that non-US citizen. It changes every year, and in 2020, it goes up with inflation. And in 2025, the amount is $190,000. In addition to the unlimited marital deduction, you can pass to anyone $19,000. You can pass it to any individual, and it is not considered a taxable gift. If you're married, obviously the two of you combined could pass $38,000 to any individual without it being considered a taxable gift. If you go over that amount, let's just say you're trying to help someone with a down payment on a house. So you loan them $119,000, not loan, you gift them $119,000. The first $19,000, no ramifications. That's part of your annual gifting. The $100,000 would be considered a taxable gift. What you would have to do is when you file your income tax return, you would also file a federal Form 709, which is a gift tax return. It's purely informational. All it says is on April 8th, I gifted $100,000 to John Jones. And you sign it and you include it with your tax return. Where it comes into play is when you die. When you die, your executor actually files what's called an IRS Form 706. The 706 lists all of your assets at your time of your death. The second line says, did you make any taxable gifts during your lifetime? Your executor will check yes and put, what was it? 100,000, and the 100,000 gets added back into your estate. So what's the benefit of doing taxable gifts? The benefit is you're getting that asset out of your estate with the appreciation from the time of the gift to the time of your death. If you held that asset in your estate, that growth, that appreciation would be included in your estate when you pass away. So the benefit of doing lifetime gifting is getting the appreciation on the taxable amount out of your estate.
I have a question. My wife is a naturalized US citizen, but she's originally from Japan. She has daughters in Japan, and she would like to, in her will, put money into an account to give to her children who are Japanese citizens. Now, I understand that the tax is going to be enormous, but I've talked to several lawyers, and they don't know exactly what the tax would be. So here's the question. If you are a US citizen, but your daughter is not, your daughter is a citizen of Japan, and in your will, you will money to your non-US citizen daughter, what is the tax rate?
Oh, that's an international tax question. You know, why the people said they didn't know is the United States has tax treaties with each country. So you would have to look at what the tax treaty is with Japan and see if they tax inheritance or they have any kind of, you know, tax system. Some countries have reciprocal agreements so that if it's taxed in the US, it's not taxed for them.
Okay.
But it would depend on the tax treaty.
Right. Okay, I understand that. But the question is, we've talked to several people and they simply shrug their shoulders and say they don't know what the tax rate is. They just know that it's high. Who knows what the tax rate is? How do I find it? I've talked to several lawyers. Each lawyer shrugs their shoulders and says it's a high tax rate, but they don't know what it is. How do you find
I
out?
mean, you could talk to an international tax attorney, or you could look up the tax agreement that they have. I don't even know if Japan has a tax agreement with it. Maybe that's why they don't know what the taxes would be. I truly cannot help you. I apologize. That's an international tax question. Sorry. Okay, so now that you decided to,
Tamara, can we ask a few more questions from the chat? There's taxes on, what is the limit on estate taxes? What is the,
okay, I was going to get into this
you are, okay,
later, but that's okay. We can talk about it now.
okay.
Federal exemption from taxes in 2025, and it goes up each year with inflation, is $13,990,000. And it is what is called portable, which means if you pass away and you're married and you give everything to your spouse, you haven't used your federal exemption because you have that unlimited amount that can pass between spouses. Your surviving spouse actually gets your exemption on top of your own exemption. So a married couple, theoretically, if they died this year, could pass almost $28 million free from federal estate taxes. New York is totally different. New York's exemption is $7,160,000, and it is not portable. And as you might have guessed, you're all sitting down, so I'm glad, because the New York estate tax exemption is totally dysfunctional. If your estate is below the exemption of $7,160,000, then you would pay no New York estate tax. But if it's over 5% of that, you lose the benefit of the entire exemption and you're taxed from $1. So to go back to the federal exemption, 28 million, let's just say you're single, so it's $13,990,000. If your estate is above that amount, anything above that amount is taxed at 40%. If you're married, it would be anything over, and you elected portability and you have both exemptions, it would be anything over a little under 28 million would be taxed at 40%. Going back to New York, if your estate is below 7,160,000, no New York taxes. If it's above that by a little amount, 5%, you lose the benefit of the entire exemption, and New York's tax rate starts at 4% and goes up to 16%. And that's for estates over a little over $10 million. So it's an incremental one. Okay.
Tamara, I have a couple more. So who pays the tax on gifts larger than 19,000?
There's no tax.
Oh, there's no tax for
Information.
19,000.
It's considered a taxable gift, but it's an informational tax return. There's no tax associated with it. I'm not assuming anybody's giving over 13,990,000. If you did, then the tax would be at 40%.
Okay.
Is that it?
Well,
I have
there's
a
one
quick
about
question.
children, but I think that you covered that, right?
I apologize, what now?
Someone asked about giving money to kids, your children, but doesn't that fall under the limits that you talked about?
Yeah, you
Okay.
can give to children during your lifetime, you can give up to $19,000 to anyone. It's not just your children. You can give it to anyone. In addition to that 19,000, if you pay for tuition directly to the institution, or you pay for medical expenses like braces directly to the medical provider, those are not counted as gifts. So you can give 19,000 plus pay for their tuition, plus pay for the medical expenses.
Can I ask a question, please, on this?
Go ahead, Elena, ask.
Thank you. So if we give, is there any advantage to us if we give $19,000 dollars as a gift to a non-profit organization? Do we pay less tax that year that we make this gift? Not to a family member, but to a non-profit organization like a library or an institution makes no profit.
I'm not sure I'm understanding. If you give any, you can give any amount to a charitable organization. Is that your question?
All right, so the non-tax, they will not pay any tax. I will not have any tax benefits by giving this gift, by making this gift.
Well, the benefit would be the items what I talked about before, you know, they're non-physical, but you know, you can see them enjoy it, you can, you know,
Right.
test their ability to manage the money. But from an income tax point of view, it doesn't, you should understand, let's just say you have Exxon stock and you bought it for $10, and when you gifted it to someone, your child, it's worth $50 a share. When you make a lifetime gift, they keep your basis. That $10 is their basis. There's no income tax consequences to your children to making that gift. There's no income tax consequences to you to make that gift. But if your child turns around and sells it at $50, they would have capital gain.
Right. All right. I understand. Thank you.
But
We're
the
gonna hold
benefit
on
doing,
to the
yeah, the
questions
benefit
today.
I have a
is
question.
more
Wait, we
intangible.
have to let her finish her presentation, and then
I
we
have a
can
quick
add our
question.
questions towards the end.
Oh,
Okay,
I've-
thank you. We just want her to get through the rest of her slides.
Okay,
ahead,
so now
Tamara.
what's the best property to give? And I kind of went over this. Any property that will appreciate substantially in value from the time you give it to the time, you know, you pass away, that all that appreciation is out of your estate. You've gifted the asset, so it's out of your estate. Life insurance is good because if you keep life insurance in your name when you pass away, the death benefit is included in your estate. If you gift it during your lifetime, the gift is actually the cash value of the life insurance. It's not the death benefit. So you're actually getting $1 or whatever the cash value out of your estate. And when you die, the 100,000 death benefit goes to your beneficiary or who you transferred it to. And then income producing property, as I mentioned, if somebody you're giving the asset to is in a lower income tax bracket than you, then net, they're going to pay less taxes on those interest and dividends than you would have if you kept them in your estate. So now let's turn to charity. There's many benefits to giving assets to charity. If you have philanthropic objectives, obviously it provides a resource for your favorite charitable organizations. And, you know, you can get maybe an income tax deduction for it. It all depends on, you know, what your other deductions are, because the standard deduction is pretty high now. Giving can take many forms. You can give outright. I mean, probably the easiest way to give to small gifts to charity is a gift of cash. The benefit, they'll benefit, consider the organizations you want to benefit and what kind of asset. Obviously, the most common way is to simply give outright gifts of cash, securities to charity. Your gift can have an immediate impact on the charity, and it's easy. If you're giving cash, you can write a check, you can use a credit card. There's also more advanced ways to give to charity. You can use trusts or a private foundation. There's basically two types of charitable trusts. There are charitable lead trust, LEAD. And when you set up that kind of trust, you give the charity an income stream from that trust for a period of years. Let's just say 5 years, they get 5% of whatever you put into that trust. And after the 5 years, the remainder in the trust can come back to you, or it can go to your children, or it can go to a friend. So you can redirect whatever remains in that trust to someone else, or you can keep it. The flip side of that is a charitable remainder trust, where you keep the income from the trust for, let's just say, your lifetime. And when you keep 5% that you put into the trust, you'll get an income tax deduction for that. And when you pass away, if there's anything remaining in that trust, it goes to the charity that you have remained that you have named as the beneficiary of that trust. And then you can do, as I mentioned, private foundations, but those are usually for very substantial gifts. So I just wanted to go over so you understand the amount of charitable deduction that you could receive from your gift. It depends both on the type of asset that you're donating and whether the charity that you're gifting to is a public charity or a private charity. So we're talking about a 501c3 charity, which is a public charity, or a private foundation, which is not a public charity. You're going to get a bigger deduction for giving to a public charity than for a private foundation. So for example, with cash, you can give up to the fair market value up to 60% of your adjusted gross income as a deduction. If you cannot use all of that charitable deduction in the year you make the gift, you get to carry it forward on your income tax return for up to the next 5 years. So you're not losing it with these limits. You really are postponing when you can take the deduction. If you gave that same amount of cash to a private foundation, you would only be able to deduct up to 30% of your adjusted gross income. But again, you would have that additional 5 years to use up the exemption. With marketable securities that are long-term, they're held for a year or more, they're great items to gift to charity because you get to, in my example with that, you pay $10 for Exxon and now it's worth $50. When you make the charitable gift, you get a deduction for $50. You don't have to recognize all that capital gain as long as it's long-term. So not only do you get the benefit of, or the potential benefit of the income tax deduction, you also are not recognizing capital gains when you make the gift. Versus if you gave that same appreciated stock to a private foundation, you would only be able to deduct up to 20% of your AGI. But again, in both instances, you have that 5-year carry forward. Now,
Quick question. if I-
Tamara, we have a couple of questions. What happens to a house that still has a mortgage?
it all depends. In most estate documents, it will say whether the mortgage is to be paid or not. So I assume you're just talking in general, you're not talking to a charity, or are you talking about a charity? If you have a house with a mortgage and you're giving it to a relative, your will say whether the mortgage gets paid off or not. For purposes of valuing it for your estate, it's the net value. It's your house is worth $100,000 and you have a $50,000 mortgage. It would be listed as both an asset and a liability. If you give it to a charity, the charity will most likely, when they get intangible gifts like this, they just try to sell it. So they would get it probably as a net amount and they would put it up for sale.
What about property in a foreign country?
Again, if you're a US citizen and you have property in a foreign country, the United States and only one other country tax worldwide assets. So it would be included in your estate, but again, it would depend on the international tax treaty that there is, because it would be subject to tax here. Whether you would get a credit against any tax that might be owed in France or Italy would depend on their agreement with the United States.
Okay, thank you.
Okay. So it's important to look at the stage of life when considering deciding what assets to give to charity. It may be more advantageous to give specific types of assets during one stage versus another.
I have a
Talk that through this chart. So if you're under 70 and a half, giving low basis long-term marketable securities has that advantage that I just mentioned. You get the fair market value as a deduction and you're not recognizing any capital gain. So it's a win-win. You get the higher valuation and you're not recognizing capital gain.
I have a quick
Charities don't
question.
pay taxes. So I'm sorry.
Hello? Hello?
You're on mute.
Okay, can you hear me now?
Yes.
Okay, I have a lot of books that I want to donate to the college library. And the question is, can I get a tax deduction for that? I have a lot of books and the library said they would accept it, but they didn't know the tax implications of that. What are the tax implications if you donate a library full of books to the university?
A library to a US university?
To the City College of New York. I have a lot of books I'd like
Yeah,
to donate
it
to.
all depends on, you can deduct it if you have enough itemized deductions. Right now, the standard deduction for a married couple is $30,000. So unless your itemized deductions, which there are very few of them anymore, you have mortgage interest, you have charitable deductions, state and local income taxes are pretty much capped at $10,000. So unless your total itemized deductions are over the standard deduction, you're going to probably take the standard deduction and not get a deduction for the books. If your if your itemized deductions are above that amount, then yes, you could get a charitable deduction for donations of books to a library. You would just have to get them valued. Okay. So as I started to say, if you're under age 70 and a half, low basis, long-term marketable securities make a lot of sense. Cash is always king. And other non-qualified assets, as I mentioned, people have given away houses, boats, etc. Those you can, you know, are good items to give to charity. When you reach age 70 and a half, you get another quiver in your bow. You can add what's called a qualified charitable distribution. So once you turn 70 and a half, you can make what's called a qualified charitable distribution, or I call it a QCD, directly from your IRA to qualified charities in the aggregate amount in 2025 of $108,000. It started at 100,000 and it's been adjusted for inflation each year. So that, while you don't get a charitable deduction for it, what happens is it's not reported as income. So instead of you having your RMD, your required minimum distribution of $15,000 becoming part of your taxable income for the year, if you're going to do charity and you do that 15,000 and give it to the American Red Cross, that 15,000 now is not going to be included in your income. So where this could be helpful for you is it could keep your Medicare premium lower, and it could also lower the amount of taxability of your Social Security benefit. So that's just something to think about. And then when you pass away, I mean, what's best assets to give away when you pass away are those assets that have built up income taxes in them. If you have non-qualified deferred comp or you have retirement plan assets, those have built up income taxes in them. So on your retirement, and the beneficiaries, if you name individuals as beneficiaries of your IRA, for example, they're going to have to pay income taxes on the distributions that they take from that inherited IRA. And if it's a non-spouse, they have to take it now under the Secure Act. They have to take everything out within 10 years. So depending on the amount that they're inheriting, that could really, you know, be a large income tax issue for them. If instead you gave some of that, named a charity as the beneficiary or a partial beneficiary of that IRA, the charitable beneficiary doesn't pay income taxes. So they're going to get the full benefit of that distribution versus an individual. And now let's turn, I'm sorry, to tax considerations when you pass away. So before you begin planning, you should take an inventory of your assets. Make sure they include not only your bank and investment accounts, but also any real estate, personal property, life insurance, and other assets. And as I mentioned, the U.S. taxes worldwide assets. So anything you own abroad is going to be included in your estate. Once you have a clear idea of the value of your estate, you can start thinking about not only who you want to leave those assets to, but also in what manner that you want to leave the assets to. So I have another pinwheel here. So what should you think about before visiting with an estate attorney? Who do you want to inherit your assets? How do you want them to inherit? The easy way is give it to them outright. You can also give it to them in trust. When do you want them to inherit your assets? And by that, I mean, if you give it to them in trust, you can delay when they get the assets. You can have them receive income and principal for a period of years, and then at age 30, they get a half of the trust outright. And then at age 40, the remainder of the trust outright. It can be designed any way you want. And you have to think about, is your beneficiary, are they capable of managing the inheritance? Are they spendthrifts? Do they have spending habits? So those are the kind of issues that you should be thinking of before you meet with an attorney. The other big question is, who's going to administer your estate? An executor is the person that administers your estate, or some people call it a personal representative. This should be someone that is very good at organizing, because if there's any taxes due, those taxes will be due 9 months from your date of death. Now, you're probably going to have an attorney helping you, but you do want to make sure that someone that you have named or an institution that you have named is good at, this is what they do and they want to do it, and they're good at organizing. So what are the other questions you should know? How important is tax minimization? From a federal point of view, it's probably not a big deal, but from a state point of view, it may be. Again, if your estate is hovering around what the New York exemption is, then you should be thinking about tax minimization. One of the items that is often overlooked when you're doing estate planning is the coordination of asset ownerships with your estate planning documents. Also, the titling of the property will determine not only who receives it, but also whether it will be subject to probate. So what's probate? Probate is when you pass away and you have a will. Your executor needs to bring a copy of that will along with a death certificate and a listing of all of your assets to the surrogate's court. In return, the judge, after reviewing what you've brought to them, they want to make sure it's a valid will give your executor what are called letters testamentary. And those letters testamentary allow your executor to change title from your name to the beneficiary's name or to the trust that you've created in your document. Doesn't sound like it's a big deal. However, you're not the only one that passed away. So the judge has stacks and stacks and stacks of these. So during that time period between when your executor has presented your will to when you get letters testamentary, your assets are frozen. So if your beneficiary needs to access your assets to pay for maintenance on your house, lawn care, bills, utility bills, they don't have access until that is gone through the court and you get letters testamentary. So that's why most people try to avoid probate. So what items go through probate? Items that are in your sole name are going to go through probate. Anything that you have jointly but titled as tenants in common will go through probate. And if you own any community property, your portion of the community property goes through probate. If you don't have a will, your assets will go by intestacy, and each state has their own intestacy laws, and those intestacy laws will determine who receives your estate. If you have joint tenancy, if you're married, most people have joint tenancy with rights of survivorship. Those pass by operation of law directly to the survivor, avoid probate. Another way for married couples to hold joint property is tenants by the entirety. Again, goes by operation of law to the survivor, avoids probate. If you put a transfer on death or a payable on death beneficiary designation on a non-retirement asset, so you have a bank account at Citibank, That's a non-retirement asset. You can ask somebody at the bank to give you a payable on death form or a transfer on death, they're interchangeable, form, and you can actually name a beneficiary on your bank account. Because of that, those assets will avoid probate. If you have a beneficiary designation, that supersedes your will, trust, anything, and will go directly to the beneficiary that you named in the TOD or the POD, transfer on death or payable on death. Retirement assets have a beneficiary designation. They go directly to your beneficiary. Unless you've named the estate, and then you're going to force those assets back into your estate. If assets are in a trust, they're going to go by the trust terms. They will not go through probate. And life insurance has beneficiary designations, which will avoid probate. So I don't know how much time we have, Talon.
We're we need to wrap it up. Tamara, thank you.
Okay, glad. We talked about wills. I think you all know what a will is. You can distribute assets, you can name an executor, you can name a guardian for a child, and you can have tax provisions. But if you don't have a will, like I mentioned, you'll go through probate, intestacy laws, irrevocable trust. If you title the assets in the name of the revocable trust while you're alive, they will avoid probate. And I just want to mention that there are very few states that have estate taxes or inheritance taxes. The states in dark blue have an estate tax. You'll see New York has it, Oregon, Washington. The states in light blue have an inheritance tax. Pennsylvania, New Jersey, Kentucky, and Nebraska. And if you're unlucky enough to have someone live on this call that lives in Maryland, you actually have both an inheritance tax and an estate tax. So thank you.
Thank you so much, Tamara. Very informative. I hope everyone found this to be a useful presentation. I'm not sure if you're able to stay on and maybe respond to some of the questions in the Q&A. If you can, I would.
Sure, I'm fine. I just didn't want to interfere with anyone else.
No, that's fine. Thank you. Our next presenter is Peter Quinn from the 457 plan. Peter, are you there?
I'm here.
Okay, great. You can begin, you can share your screen and begin your presentation.
Great. Let me get this. And just let me know if you can see that.
Yes,
Okay,
we
see
can
a
see
nod.
it.
Okay, great.
We can see it. Just if you can make it a full screen, then.
How's that?
Yep, perfect.
Okay, good morning, everyone. Again, my name's Peter Quinn. I'm the New York Metro rep for the New York State Deferred Comp. We have 12 reps around the state from, Buffalo, Rochester, Albany, myself for New York City, all the way out to Montauk Point. So we help support the New York State Deferred Comp. Our main role is to help people get enrolled in the plan, but we're also here to answer any questions that you might have. I realize that a lot of people on the call today are probably already enrolled. This is the enrollment presentation, but I think this does the best job explaining all the features of the program. If you could put yourself on mute, that would be great. Thank you. So I'm going to go through this again. We're here to answer any questions. This is going to go through all the features and benefits of the program. But the other thing is I'm also available for one-on-one consultations. I'm going to send Talon a follow-up email. It'll have the highlights of the program. It'll have a list of the funds that are part of the program. The PowerPoint presentation that I'm going to go through, I'll attach to the email. But on the bottom of my email signature is a button, and you can actually book a one-on-one appointment with me if you want. And a lot of people, just reading an article in the journal today, they look at their, 401k plan, maybe not on a regular basis. I think with everything that's going on in the market, maybe you look at it a little bit more frequently. But it is something that you should take time, a couple of times a year, to go through and review it, make sure it's, kind of doing what it's supposed to, and that you're going to have enough money to live comfortably in retirement. And I use my daughter as an analogy. She still lives at home. She's out of school and she likes to travel. She probably does like 2 trips a year. And she'll spend hours figuring out, well, where are we going to go? It's usually with her college roommates. What are the cheapest fares? What are we going to do when we get there? What are the best hotels? And, for every trip, it's a couple of hours of just spending time reviewing what she's going to do. And I think you got to think of your retirement the same way. It's one long vacation, and you want to make sure you look at it on a regular basis leading up to retirement. So with that, I'm going to go through the presentation, and happy to answer any questions as we go through it, or if you want to put it in the chat, maybe Talon can read those questions as we go through. But what is the deferred compensation plan? This is a supplemental retirement program. It's also known as a 457B plan. And 457 is just a code section that spells out an IRS code section that spells out the rules for the plan, how it should work. Other types of retirement plans are 401k plans. That's an IRS code section, IRS code 401, K. 403B plans are also retirement plans. But if you think about it, this is just like a 401k plan for state employees. It allows them to defer part of their income into this retirement plan through payroll. So these are a really simple way to contribute to a retirement program because it's done every pay period. You decide how much you want to put away. You have to remember that everything with this program is yours. You have total flexibility as far as what you want to do. And the contributions to the plan can go in either pre-tax or after-tax Roth. And I'll explain the difference between the two. Let's say you're making $100,000 a year, and over the year, you're going to put away 10% of your salary or $10,000 into the plan. If you do it on a pre-tax basis, you're getting a deduction for the $10,000. So you're not paying tax on $100,000 because of the deduction. You're getting taxed on $90,000. So there's a benefit there, for people who want to lower their taxes. The contribution that you make, that $10,000, grows tax deferred. What I mean by that is wherever you have the money invested, any growth on that, you're not paying taxes. But when you pull the money out of retirement, that's when the government gets their money. As you pull money out of the plan, however much that is per year, you'll get a 1099 and you'll have to report that as income. So that's one option, pre-tax. The other option is after-tax Roth. And using the same example, you're making $100,000 a year, you're putting away 10% or $10,000, but you're doing it on an after-tax basis. So you're not getting a deduction for that $10,000. So you're going to pay tax on the full $100,000 of income. The money still grows tax deferred. So any growth on that $10,000, that after-tax $10,000 contribution, you're not paying tax on it. And here's the benefit, huge benefit. And a lot of financial advisors and financial gurus say, max out on your Roth. When you pull the money out of retirement, it's tax-free. So think about it. You're going to have a state pension that's taxable. When you start taking Social Security, that's going to be taxable. Why not create this bucket of money that you're going to have to the side in this program that when you pull the money out, it's not taxable? So it's a huge benefit, something to think about financially. It's not all or nothing. You don't have to choose, well, am I going to do pre-tax or I'm going to do Roth? If you're putting away 10% of your pay, you may do 5% pre-tax, 5% Roth, and you'll have two separate accounts within this 457 deferred comp plan. And again, in both situations, as you see on the bottom bullet, the growth on the money is tax deferred. You're not paying tax on the increase in the investment. Important thing to remember is this is your plan. You get to decide how much you want to put away. I always try to tell people, kind of aim high. If it's too much coming out of your check, you can always lower it. Because a lot of people will go in low, let's say at 1%, which is the minimum. And then 5 years later, they're like, boy, I wish I, had put more money away, because they kind of set it and forget it. But you have flexibility on changing how much you want to put away. If you're getting a paycheck, if something comes up where it's an emergency and you have to lower your contribution, you can do that at any time. It may just take a pay period or two for that change to take place, to coordinate with your payroll and our back office. You get to decide where you want to invest the money, and I'll talk about the options there. And again, everything is totally flexible. You can make changes at any time, including your beneficiary designation. So maybe you're not married, you name your mom and dad as the beneficiary, you get married, you can go and change that to your spouse. So total control. Again, remember, this is your plan, your account. The part that freaks a lot of people out are the investment options. Hey, Pete, I'm not that great with investments. This is my first exposure to investments, not sure what to do. We have two options. One, we can do it for you, and we would put you in a target date fund. And what a target date fund is, a mutual fund that is targeted towards the year that you're going to retire. So this year is 2025. If you were coming into the plan and you're going to retire 20 years from now, you would go into a 2045 target date fund. If you are retiring within a few years, you come into the plan today and you're going to retire in 5 years, we put you in a 2030 fund. The difference is the money manager, the person investing that fund, knows, hey, I have 20 years to go to retirement. I could be a little bit more aggressive versus somebody who has 5 years to go to retirement, maybe a little bit concerned about losing money in that short term, probably be a little bit more conservative. And I'll show you examples of both in a second. The other option is do it yourself. We have about 20 different funds that you can choose from the most conservative to aggressive programs. The one thing that I do tell people, don't invest in all 20, pick 4 or 5 funds that, meet your risk tolerance. Maybe you're putting into 5 funds, 20% of your contribution going to each one of those funds. Or if it's 4, maybe it's 25%. It doesn't have to be an even percentage. It could be, maybe you want to weight a little bit more towards one fund. But those are the two options. We could do it for you, or you could do it yourself. If we do it for you, again, we're putting you into a target date fund. These funds are offered in 5-year increments. And again, there's a fund manager who's going to manage this fund. It's invested in a lot of different stocks within that specific fund. So, it's very well diversified. Here's an example of the different funds. If you have, 5 years to go to retirement, you came into the plan, you would go into a 2030 fund. The example that I said before, 20 years to go to retirement, you'd be put into or defaulted into a 2045 fund. Going all the way to the top, you're in your 20s, 40 years to go to retirement, you'd go into that 2065 fund. And again, as you go up in numbers there from 2025 to 2065, the 2065 funds are more aggressive than the ones that are closer to today. So here's what a typical target date fund looks like. This is the 2045 fund. If you were coming in and you had 20 years to go to retirement, it started out with the plan being a little bit more aggressive. As you could see with the blue, most of the money would be into stocks, a very small amount in fixed income or bonds. But as you get closer to retirement date, that's that 0 in the middle, the money manager starts adding more bonds, more of a bond mix. So at retirement, you're about 50-50 between stocks and bonds. And then they continue to manage it through retirement, becoming even more conservative, where, if you're 20 years into retirement, you're probably 75% bonds, 25% stocks. The other option is doing it yourself. And this is for people who, want a little bit more hands-on approach. Maybe you do some investing outside the plan, or maybe you even have your own financial advisor. We have about 20 different funds that you can choose from again, very conservative to, more aggressive investments. They are mutual funds, so you're not investing in one particular stock. Each mutual fund probably has anywhere between 75 and 100 different stocks. So if, one stock does not do well, there's 99 other stocks to help support that. So it's very well diversified. And you don't want to, again, pick all 20. You want to pick 3, 4, 5 funds that meet your risk tolerance and, your appetite for whatever you want to invest in. This is a tough slide to see, and I'll pull up our fund list towards the end. But this shows all the different funds that we have available, from bottom left being the most conservative. That's our stable income fund. Think of that almost like a money market fund. You're not even invested in the market. The problem there, I mean, you won't lose a dime if you have your money in that, but you're only earning 2.9%. As you go from bottom left to the top right, you're becoming a little bit more aggressive. That third box there is a balanced fund. That's a great fund. Again, I can't make recommendations, but as far as being a nice mix of stocks and bonds, that's 65% stocks, 35% bonds. And that did last year, not at 12/31, not counting the last month or so. That did about a 15% return, 14.88. In the middle, you have large cap. A large cap fund is the biggest companies, the biggest companies in the U.S., the Fortune 500. This, as an asset class, as of 12/31, did very well last year, anywhere between 25 and 35% return. And then as you continue up the ladder, you get into a little bit more aggressive investments. A lot of people like to put some money in international because they figured, so a lot of times in years when the U.S. market doesn't do well, the international market does well. So that's another option. And, most people don't put a large amount in international, but it's just a way to diversify your portfolio. So the government has annual limits on what is the maximum you can contribute to a 457 plan. The regular limit for an individual is $23,500. This goes up every year with cost of living. It was $23,000 in 2024, went up to $23,500 for this year. If you're above age 50, this is the catch-up provision. In addition to the $23,500, you can do an additional $7,500, bringing the total for someone above age 50 to $31,000. And then brand new for this year, we never had this catch-up. If you're between the ages of 60 and 63, you could do the $23,500 plus an additional $11,250, bringing your total to $34,750. And again, unique to 457 plans, deferred comp plans for the state, is a special retirement catch-up. Let's say you're within a few years of retirement and you have a lot of unused vacation, a lot of unused sick time, and you're going to get that one big check and you don't want to be taxed on it, on that check. You could actually put away up to $47,000 and defer maybe that whole check into the plan on a pre-tax basis. Requires a little bit of timing. You have to go and find out, well, what's that check amount? How much is that going to be? What date is that going to be paid to me? And then you would just go into the system and change your deferral amount. Maybe you've been doing 10% and you'd like, 70% of that check to be put in. You just make that change and then flip it back to the 10% after the check's been paid to you. So that is special to deferred comp plans. This is an example of a pre-tax contribution and the impact that it's going to have on your paycheck. Let's say you're going to defer $100 per pay period into the deferred comp plan, and you're in a 25% tax bracket. The impact on your check isn't the full $100 because you're getting the deduction. It's probably more like $75. Again, under this scenario, you didn't pay tax on the $100. The money grows tax deferred, meaning any growth you're not paying tax on. But when you pull the money out, that's when the income tax is due. The Roth works totally opposite. You don't get the deduction. You feel the full impact of the $100. The money grows tax deferred, but when you pull it out, it's tax free. So some questions regarding deferred comp. When can I start pulling money out? You can actually start pulling money out once you leave your employer. So if you leave the college, you have a balance in your deferred comp plan, you could start pulling money out of the deferred comp regardless of your age. At some point, if you look at the last bullet, the government requires you to start pulling distributions out of the plan. Those are called required minimum distributions. This used to be at age 70 and a half. Recent tax law change has moved this to age 73. So you can't leave the money in there forever. You have to start pulling small amounts out. They're very small. It's typically 3 or 4% of your account balance. So if you had, $200,000 account balance and your deferred comp, you'd probably have to pull out around $6,000, $7,000 a year. The exception is if you're still working after 73, you're not required to take your required minimum distribution until you stop working. Again, the minimum distribution is just the minimum amount. You're always allowed to take more than that. So if your required minimum distribution at 73 is 6,000, but you need 10,000 to live on, at any point you could pull out however much you need to live on in the program. But again, just a point so that you do have to start taking some distributions from the plan, and that starts at 73. What are your options for taking distributions? You hit retirement, you can actually pull the full amount out, maybe roll it over to an IRA if you want. You could take random distributions. You know what? I've been working 30, 40 years. I want to take that trip to Europe. I'm going to take, $25,000 as a distribution from the plan to go take that trip. A lot of people take systematic payments. And this is an important exercise for everybody to do, whether you're close to retirement or, even, someone just starting working. It's a good idea to get a handle on what are your monthly expenses. So what am I paying in rent every month? What am I paying for my car payment? What's my food grocery bill? We go out to eat once or twice a week. Write down all those things and get a feel for what your monthly spending habit is. One, it's a good thing because you see, sometimes it's on frivolous things and you could really reduce your monthly expenses by, just keeping track of that. But it's really good when you're close to retirement because let's say your monthly expenses are $5,000 a month. Let's say from your state pension and from other retirement income, you're going to have $4,000 come in. You could just give us a call and say, you know what? I need $1,000 a month from my deferred comp plan put into my checking account each month to cover my expenses. And so that's an option. We can do systematic payments into your checking account. And you could do a fixed amount or a term. So a lot of people will do that. Hey, put $1,000 a month into my checking account. But then when I start taking Social Security and I'm getting, $3,000, $4,000 a month from Social Security, I could shut that off. So it's not, again, anything that's locked in. Again, an important thing to remember is everything that I'm telling you about the plan is totally flexible. When you hit retirement, you're not required to pull money out. In fact, a lot of people roll money into this to have, look at their retirement assets all in one place. You can have potentially lower fees. So this plan is for anyone who's paid for or paid by the state, who's a public employee. We have 260,000 participants from Buffalo, Rochester, Albany, again to Montauk Point. We have $45 billion in this plan. This is one of the largest retirement plans in the country. So when we go to the investment companies, we get the lowest fees on these mutual funds. You also get a lot of unbiased educational services, things like what Talon set up today. You're getting from us. We do regular seminars on Social Security, Medicare, different things. Those go out from our back office on a regular basis, and we have speakers going through that. And as I mentioned before, you can roll over other retirement assets into this program. Just as a direct rollover. Direct rollovers aren't taxed. It goes from one plan to the next. So if you were part of a 401k before you started working for CUNY or a 403b, those dollars can be rolled into the program. And again, some people just do this out of simplicity because, hey, let me go to one place and see all my retirement assets. Some people do it because, again, the fees in this program are very, very low. I'm going to finish up here. And again, I think most people probably on the line are already enrolled, but I want to just show you, some screenshots of the website. It's actually been updated, so it looks a little bit cleaner and fresher, but, there's a button just to enroll. There's a lot of different tabs in here. I'm going to switch in a second to the website just to give you an idea. It's real easy. You set up your Social Security number, date of birth. You put in all your personal information. You create a username and a password. You would select that second radio button, the CUNY, and the college that you're associated with. And you get defaulted into a target date fund. You can go back in and choose your own funds if you want. And then you just decide, do I want money put away pre-tax? Do I want to do Roth, or do I want to do a combination of both? And you're enrolled in the plan. So I am going to stop sharing for 1 second. Helen, how much time do I have? 2 minutes?
That's fine.
And share screen. So this is one of the things I'm going to email Alan. It's a list of all the funds and their performance. Oh boy, they updated it as of 12/31. Yesterday I had up the I'm sorry, as of March 31. Yesterday I had up the 12/31. But it shows you the most conservative investments. Again, the stable income, you're not even in the market. But the return on this is not great, but you don't have any risk of losing money. So a couple of things this sheet shows
Your
is
slide is not up.
it's not up. Thank you for sharing that. Is it up now?
No, not yet.
Huh. Okay, let me try to share this. Share screen. Got it. All right. How about now?
Yeah.
Yes.
Okay. So these are, let me explain this sheet to you. It shows all the funds that are part of the plan, including the target date funds towards the middle. It shows the 1, 3, and 5-year return. And it also shows the expenses of that fund. And again, these are very low. So the stable income, again, 2.9%. It's Wellington, again, took a pretty big hit. This was at almost 15% because of the market. The last quarter here has gone down. Oh, but you know what? This is year-to-date performance. So this is just showing. I apologize because this is the first time I'm seeing this. It just came up today. So this is just showing from January 1st to um to 3/31. But it shows you all the different returns on the different investments in the plan. Again, a big difference with this last quarter, but you can see it goes from the stable income to the balanced fund, all the different target date funds, the large cap, all the way to international. So that's something that you can look at when I send that email to Talon. That's pretty much it. Uh, Part of the email that you'll get will be a button below my email signature where you can just look at my calendar, book an appointment. The great thing about this is everybody's financial situation is different. So we can kind of talk about, what makes sense for you. Some people say, well, I understand the benefit of the Roth, but I like the idea of reducing my taxable income, so I'm going to do the pre-tax. But with that, I will end the presentation. And if anyone has any questions, either put them in the chat or you can just unmute and ask me.
Thanks so much, Peter. I appreciate your time.
Yeah.
At this time, I'm going to share the link for the TRS Zoom. I just put it in the chat, so whoever is a TRS participant should utilize that link and go to the other meeting with the TRS representative. Anybody who's a participant in TIAA will remain here. And Peter, if you can look at the chat, at the Q&A, and there's some questions there for you. If you can answer them, I would appreciate that.
The first one, does a revocable trust handle the
Well,
disbursement?
just read it on your own and type it in. I want to move on to the next presenter.
Okay, I'm going to sign off here, but thank you.
Hi, Grant. How are you today?
I am doing well. How are you doing today?
Pretty good.
Give me 1 second as I get my pulled up and then I can share my screen.
Okay, I think I made you a host, right?
I think so.
Okay, great. Everybody in TRS, you can go on to the next presentation. The link is in the chat.
Right. And Talon, does that look good? Can you see my slides?
Yep, I could see them.
Perfect. All right. And if everyone could go on mute for me, that would be awesome as I jump right in. But thank you all for having me today. My name is Grant Trish. I am a financial consultant